to welcome Jim Wright from the Office of the Property Rights Ombudsman. I'm going to quickly throw it over to you. Let's see. You should have a bubble pop up there. Can you see it yet?
No.
Let me try that one more time. It might be behind a window. Let me try it one more time. Maybe I need to click the bubble. Is that working now?
I'll share my desktop. Yep, I think we have it.
Awesome.
I'll bring up your presentation. Okay, we looking good?
You are looking great.
Okay. Well, thanks, Jason. I sure appreciate that, and as always, we appreciate the invite to be here. And as you mentioned, I'm Jim Wright from the Office of the Property Rights Ombudsman, and we're going to talk about takings today. And takings, it's a pretty broad area of law. We could have an entire semester-long course on this, but my hope is that we're going to be able to condense this down to the 40-ish minutes we have, and that I'll be able to provide you with a nice refresher on takings, or in some cases maybe some new information about takings law that will be helpful as you interact with the private property owners in whatever capacity you do so. Again, there's going to be far more in this area of law than we could possibly cover, but I think that we've been able to distill this down and condense it to things that will be ultimately helpful to you. Of course, I'm happy to take questions at any time. Doug promised he'd let me know, since I can't read the screen, if some questions come in. I'm happy to take them during the presentation or at the end. The purpose, of course, always is to be as helpful to you as we can be. Given that this is, again, such a broad area of law, I won't be afraid to say that I might need to get back to you on something. And, of course, you're always free to call up and continue this conversation with us. Call us in the office, and we're happy to take a look at things further, or if something comes up after the presentation that you want to talk about, give us a call. We're there to help. So with that, let's go ahead and jump in. So the way I'd like to proceed here is by starting with the legal foundations relating to takings. It's grounded in constitutional principles of law, but I also want to go over a couple of property rights concepts as an initial matter, so that we can contextualize this and have it make sense as to what exactly we're talking about when we talk about takings. And then there are three main categories of takings I'd like to address. There's the physical takings, the regulatory takings, and then the development exactions that we can go over. Now, there's different analysis that applies to these various areas, and so I want to go over that to give you some tools so that you can best know whether a situation you're dealing with has potential takings implications. And I know that I'm probably addressing a majority of people who are not attorneys, and so I thought this quote from Justice Brennan was a good one to set us off here, and that is, after all, if a policeman must know the Constitution, then why not a planner? And I think that gets to the heart of the issue, that it's not just attorneys that should be aware of these issues, and he gave this in a takings case, but it really is something that's important for anybody, any government official that deals with issues that may implicate takings rights or property rights. Okay. So on the legal foundations, I'd like to start here with property rights generally, because even though takings law is rooted in the Constitution, we'll get to that as you can see just below there, property rights themselves don't originate with the Constitution. Property rights came from, largely come from common law or from, legislative enactments. And the common law dates back to a lot of it from England, and some of it as far back as the Magna Carta. And so in law school, most law students, including myself, learn about property rights with an analogy of property rights to a bundle of sticks, where each different property right is analogized to a stick in this bundle of sticks. And so say I own fee simple title to property, or I own all the property and all property rights. I would have lots of different rights that can be broken down in that ownership. For example, one of my sticks in this bundle of sticks might be the right to exclude people, or would be the right to exclude people from my property. That's a right I have. Another right would be to develop my property. Another one would be to make beneficial use of my property, or perhaps sell the property, or lease the property. And so, for example, I can convey away some or all of these rights. Say I wanted to allow someone else to have the right to occupy my property for a certain term, and then I would maintain the right to repossess the property at the end of that term. That would be a lease. Or if I wanted to give someone the right to occupy a certain portion of my property for a specific purpose, that would be an easement. And so there are various property rights here that make up this bundle of sticks. And so when we talk about takings, we're going to be talking about taking some or all of these rights. And so I just wanted to make sure we had that as a foundation here before we jump into the specifics of takings. So a definition of a taking is any interference with or appropriation of a property right for a public purpose to the point that just compensation is required under the Constitution. And so obviously that definition alone is not going to tell you when an action that you are taking may require just compensation. But ultimately, we're very lucky that the courts have given us much more guidance as to when the payment of just compensation will be required. But that's ultimately what a taking is. It's when we've interfered with property rights to the extent that we have to pay just compensation under the Constitution. Because as mentioned, the takings issue does come from the Constitution here. In the Fifth Amendment, we have the constitutional right not to have our private property taken for public use without just compensation. And there's a similar provision here in Article 1, Section 22 of the Utah Constitution that says the same thing with the addition of shall not be taken, or this is the addition, or damaged for public use without just compensation. And as a practical matter, Utah courts have looked and addressed the or damaged portion of that clause, but as a practical matter, it's not really going to be that different from the rights under the federal Constitution, because the federal Constitution has traditionally been viewed fairly broadly, and so it's going to encompass the damaged portion of the state constitution in any event. And about half the states in the country have that or damaged clause in their similar state constitutions on property rights. So there's sort of a brief overview of some of the legal foundations of takings and what we're going to be talking about and where the subject originates from. Okay. Of course, as we're all aware, there is a tension between the private property rights and desires of individuals and what is ultimately in the public's best interest for safety, for an orderly society. There's tensions between the collective rights and the individual rights. And I felt like these two quotes here from some of our Supreme Court justices relating to takings do a nice job of highlighting that. So the first one from Justice Anthony Kennedy: these inquiries are informed by the purpose of the Takings Clause, which is to prevent the government from forcing some people alone to bear public burdens which, in all fairness and justice, should be borne by the public as a whole. And then this quote from one of America's greatest jurists here, Oliver Wendell Holmes: we are in danger of forgetting that a strong public desire to improve the public condition is not enough to warrant achieving the desire by a shorter cut than the constitutional way of paying for the change. And so, there's certainly an acknowledgement there of this tension, but we have to remember that just because something is for the public good or maybe even necessary for public safety doesn't mean that an individual has to be the one to bear all that burden. And so let's jump in here and get a little more specific. So I mentioned we were going to be talking about 3 different kinds of takings, and we'll start with the physical takings. The good news here on this one, at least for the first kind of physical taking we'll talk about, where there's a permanent physical occupation, is the courts have been able to give us some pretty good guidance on this, and these are usually fairly easy cases to determine. That won't necessarily be the case for the rest of what we talk about, but we'll start off with the easy cases. So, whenever there's a permanent physical occupation, courts have said there's, by government for public purpose, there's going to be a taking and just compensation will be required. And so, in this important case, Loretto v. Teleprompter, coming out of New York City, the court made that clear, and in subsequent cases, it's confirmed that. And in the Loretto case, Ms. Loretto owned an apartment complex in New York City, and the city passed a law saying that property owners had to allow cable companies to place a cable box on their property. And they said that this was for the public purpose of furthering education and the dissemination of culture in society, because at the time, cable was much more, the companies themselves were a much more important part through their technology of cable boxes of disseminating important information and culture. It was the pre-internet days. And in order to do that, the court said, well, every owner needs to allow this little cable box to be installed on their property. And this box was not large. It did not interfere with Ms. Loretto's use of her property. She hardly even knew it was there, and frankly didn't even know it was there for a while. But when she took it all the way up to the Supreme Court said that a government cannot require anyone to allow a third party or a government to occupy any portion of their property permanently without the payment of just compensation. And the court said that this is because the right to exclude is such a fundamental and important right that it was going to be what's called a per se taking. And so anytime there's an occupation, a permanent occupation of someone's property or an appropriation of their property, there's going to be a taking that requires just compensation. So what comes through our office a lot are roads. So say, for example, on occasion, we'll have someone call up and say that there was a road, or sometimes even cable lines that are strung over property without any payment for either the area where the road is or for an easement for the wires. And in those cases, that sort of occupation is a per se taking, and just compensation is required, under the principles set forth in the Loretto case. Now, not all takings or occupations are permanent. Sometimes there are temporary occupations. Let's go back again to what we see quite a bit through our office, which is road construction or road widening. Oftentimes governments will get a temporary construction easement to facilitate the construction of the road, so that the tractors can go and do what they need to do on property that's wider than the road itself is going to be, and they can have a staging area to store their materials and go ahead and construct the road. But on occasion, people will call up and say, hey, I've got these tractors and construction folks here on my property, and there's no easement, and it's my private property. And that's problematic. And now, to determine whether or not it rises to the level of taking, what courts have given us as guidance is they have said that the longer the intrusion lasts, the more likely it is to be a taking, as well as the more intensive the intrusion is, the more likely it is to be a taking. So, for example, say while constructing a road, a tractor ends up driving up on somebody's driveway on their private property outside of any easement a couple of times over the course of the 2 months that the road is being constructed in front of their house. That's not a super intrusive use of their property. Tractor drives up and around and back off. And it also doesn't happen for all that long. So there's probably a pretty good chance in that case, that is not a taking. Of course, that does not mean it's legal. And I have to be clear about that. It's not legal. It's a trespass. It's illegal. And it shouldn't be done. But the remedy is not a takings remedy under the Constitution. It's a separate remedy under the trespass law of the state. On the other extreme, though, we see sometimes, say, for example, during this road construction, a construction company uses someone's front yard as a staging area where they store construction materials that are there full time for a few weeks. That, on the other hand, is much more likely to rise to the level of a taking, and we would say, depending on the specific facts, likely is a taking that would require payment of just compensation. And so the difference is, how long does it last, but also what's the intensity of use? And so maybe just to give you a specific example of a case, when some governmental biologists went briefly onto private property a couple of times over the course of a few months, the court said, no taking. That was not long enough, and it was not an intrusive enough use to justify a taking. The flip side, of course, is when, an example like where I mentioned, where someone uses private property as if they had a temporary construction easement, for basically full-time occupation for a couple months. That's going to be a taking. So again, I can't give you a bright line on that one, but be aware that any use of private property without permission is illegal. In terms of for like a construction use, and unless there's some legal right to be there through an easement or because of some sort of exception for an emergency or some other exception like that, even if it's not a taking, it's a trespass. So that's important to keep in mind. So that's the physical takings. Next, let's talk about regulatory takings. And so, regulatory takings, of course, arise from various regulations, be they, for example, zoning regulations or environmental regulations or other regulations that may impact somebody's property. And we'll go back to here the great Oliver Wendell Holmes, who gave a great quote here out of a famous takings case. He says, "The general rule, at least, is that while property may be regulated to a certain extent, if regulation goes too far, it will be recognized as a taking." And of course, we're sitting here wondering, well, what does it mean to go too far? And again, luckily the court has given us some guidance, although not as much guidance as they have on the physical occupations, as to when a government has gone too far with a regulatory taking. And so let's take a look at a couple of these here. So the first case comes when the government has imposed a regulation that takes away all economically beneficial use of the property and all value of the property. And the preeminent case on this is the U.S. Supreme Court case of Lucas v. South Carolina Coastal Council. And in that case, Mr. Lucas had purchased a couple of beach lots in South Carolina, and he wanted to develop homes on them. And there were adjacent properties that had developed beach homes to the lots where that he purchased. And the South Carolina Coastal Council said, you know what, this isn't a hurricane zone. We are going to prohibit you from building anything on these lots. These lots have to stay as vacant lots. And Mr. Lucas took this case all the way to the U.S. Supreme Court. And the Supreme Court said that because a lower court found that his ability to use a lot for anything beneficial, for any economically beneficial use, as well as the total value of his property was gone, it had been wiped out by this regulation, the Supreme Court said that this was a taking and that just compensation for his full property was required. And so the court did clarify that just because any use of a property is prohibited, it does not necessarily mean that a taking has happened if the only uses that were possible on the property would have constituted a nuisance under the background property laws of the applicable state. Because people don't have a private property right to use their property in a manner that would be a nuisance. The example of the court, one of the examples the court gives is that say there were a property that were located on a fault line where there was going to be a high probability of an earthquake. say the only use of that property were for a nuclear power plant, the court said that there would not be a taking if there were a regulation imposed to prohibit the use of that property for a power plant, because to do so would constitute a nuisance, and therefore there was no right that was taken away. So the court also said that these Lucas-style complete regulatory takings are fairly rare, and so that most likely the cases that you're going to be running up against on the regulatory taking side will not be the Lucas type of taking, but in case they are, you know what the applicable regulation is. What is much more likely, though, is what's called the Penn Central type of regulatory taking. And the Supreme Court has set forth a three-part analysis to determine whether or not a regulatory taking that stops short of removing all value of the property or any economically beneficial use of the property, when does that rise to the level of a taking so that just compensation is required under the Constitution? And so in the Penn Central case, that is also from New York City, the owners of the Grand Central Station wanted to build a skyscraper above the Grand Central Station. And New York came and said, you know what, we're not going to allow you to do this because of the historic significance of this building. And so you cannot build anything or do anything else to this property other than to keep using it as the Grand Central Station. And the owners sued, and at the Supreme Court, the court said that even though the city had taken away their air rights and had taken away their ability to use the property for another use that would be much more profitable to them, there was no taking. And the reason why, the court said, is because they were able to continue using the property for the same use that they had been using it for the previous multiple decades. And so in that case, there was not a taking. But the court also announced this three-part test to determine whether or not a regulatory imposition would constitute a taking. And so let's go through these steps here and talk about them so that you can apply them to a situation that may come up for you in your particular situation or context. So the first is the extent of the economic impact. And the courts and other courts since the Penn Central case have indicated that this is the preeminent consideration. So you're simply not going to be able to get a regulatory takings claim to stick unless you can show that there's been some serious economic impact. And again, I wish I could give you a bright line rule as to what percentage in the decline of the property value has to happen for there to be able to be a taking, but courts just simply haven't given us that guidance. What I can say, though, is that courts have found a taking in a case where a property has been devalued by as little as 62.5%, but that in most cases, courts are not finding takings even when the value has been reduced by up to 90%, or even sometimes over 90%. And the nice thing here on this particular question is there's a case out of Utah, the Smith Development case that involved the property owners in Sandy. In that case, they had property that was zoned as a commercial use. Sandy rezoned the property to residential, and that caused the value of the property to drop by 43%. And the Utah Court of Appeals found that in that case there was no taking. And so that's a specific case we have from Utah that has analyzed that. But as a general rule, most zoning decisions just aren't going to impact property values to the extent that you probably really realistically need to be in to meet that threshold, which is in many cases the 75, 85, even sometimes more percentage of a reduction. But that's not the only prong in this test. So another prong here is the investment-backed expectations of the owner. So for example, say someone bought some property to use as a ranch, and they were able to use it as a ranch for many decades. And if at the end of those many decades they decided they wanted to go and develop the property, and there was some sort of regulation that were imposed that precluded them from doing that, and they had to continue using it as a ranch, much like in Penn Central, courts are not inclined to find that that is going to be a taking. Because when the folks bought it, they were able to use it for the purpose for which they bought it, and their expectation was to use it as a ranch. Another example from a specific case where a court found no taking was an instance where an individual bought some property that was subject to environmental regulations that reduced the development that could happen on that property. This individual bought it for $100,000 when the market value of the property would have been $400,000 without these regulations. And because the individual bought it for the $100,000, the court said, you know what, your reasonable investment-backed expectations haven't been violated here. You got what you expected with the price you paid for the property. And so, that's one other element here that needs to get checked when you are trying to consider whether or not a particular regulation in any specific instance would rise to the level of a taking requiring just compensation under the Constitution. And the final prong here is the character of the government action. So, for example, sometimes governments have to impose regulations that do impact private property, sometimes quite severely, but if it's in, say, for example, the time of war, or if it's to important regulations that are critical for the health and the safety of the public, then the courts are much less likely to find that there is a taking for those kinds of reasons. However, on occasion, people are able to show that government has acted in a way that is, in bad faith. And so, if there is government action that is in bad faith, courts have said, well, that ends up going more in the direction of finding a taking. But I do want to stress again, though, that really in any of these contexts, based on the sort of global view of the cases that they've been coming down, mean that there has to be a pretty significant economic impact on the property before you can even, despite these other...
Jim, I think we're having some trouble with your audio there for a second.
Okay. I was hearing some weird noises.
Coming in and out. Doug, are you muted?
Yes.
Try it again, Jim.
Okay. Is this sounding better?
Yep, I got you there. I think it might have been a bandwidth issue. Sorry, folks.
No worries.
You may want to backtrack about 30 seconds.
Okay. So, basically, with the character of the government action, it's going to matter whether or not the government is doing things, for example, for important public purposes, like, say, for example, in war, if they have to regulate property in some way that burdens private property, or, for example, to help...
We've lost you again, Jim.
Okay.
Can you hear Doug?
Yeah, I can hear.
You've got it coming through your mic, through your headphones?
Yeah, I can hear him coming through my mic, my headphones.
Okay. All right. Maybe it's a bandwidth issue on my end. Apologize for that. Go ahead, Jim.
Okay. But if the government acts in a way that is in bad faith, then that is much more likely to help a taking to be found. But again, I just want to reemphasize that the courts, in looking at the full body of the case law, they've indicated that as a threshold matter, you really got to have a situation where there's been a significant economic impact to the property. And so that's sort of the framework for evaluating regulatory takings to decide whether or not what you have may violate someone's constitutional rights. Just to say again, in most situations, the various zoning changes and things of that nature will not rise to a constitutional takings issue. But since we're not able to give necessarily any bright line rule that can be applied across the board, if there's any questions, it's probably best you consult with your attorney or give our office a call. We'd be happy to walk through things with you and talk it over. So with that, let's go ahead and move on to the next type of a taking here, and that's development exactions. And so development exactions are sort of a hybrid between the first two types of takings we talked about, the physical occupation and then a regulatory taking. Well, let's read here this definition of exaction that came from a famous case here out of Utah, the BAM case. So an exaction is a government-mandated contribution of property imposed as a condition of approving a developer's project. And I would add that other cases here in Utah, as well as this case we'll get to in a second, the Kuntz case out of Florida, have clarified that it applies not just to a contribution of property, but also to the payment of money. And so, it's that hybrid because of this nexus between the property that oftentimes accompanies exactions, the requirement to pay money, and then the regulatory aspect of determining whether or not to approve a development or a project. And so because it's this fusion between these two types of takings, courts have carved out a sort of their own analysis for development exactions. And like I said here, there was this famous case of Kuntz out of Florida that just came down, and it clarified a lot of things in this exactions area by saying that it does not matter whether or not an application is approved subject to the developer agreeing to the exaction conditions, or whether it is denied until the developer agrees to the exaction conditions, or whether the exactions are not just an exaction of land, but also an exaction of money. The court said none of that matters. It's going to be the same analysis in any situation, and so that did clarify this field, certainly in the analysis that has to happen here. So let's jump into more of the analysis here. Just looking at the time, I think I'll skip the commentary on the Kuntz case more in depth. I let you know the important points from that case. And so here what we have are the requirements from the applicable Supreme Court cases about how you analyze a development exactions case. And as I mentioned, there's the BAM line of cases here in Utah, where the Utah Supreme Court took the applicable U.S. Supreme Court cases and made them a little more friendly and a little more easy for governments to analyze and find out whether or not their exaction is going to meet the constitutional standards. And I've also put up here a code site. It's been codified in Utah statute. I only have the municipal code there referenced, but there's a parallel provision for counties as well. I've already put too much information on these slides. There's too much text. I've violated the rules that you're told when you are doing a PowerPoint presentation, but I wanted to try to give you something that you could reference in writing to be helpful, so you wouldn't have to go back and hear me ramble on about takings to figure out, now, what was the point of this bullet point, or where can I find that information? So anyway, that's there for you. But the first requirement for an exaction is that there has to be an essential nexus between a legitimate government interest and the exaction. And this comes out of the Nolan v. California Coastal Commission case. And this was the first of the U.S. Supreme Court cases that's really helped drill down on what the requirements are for development exactions. In that case, the Nolans wanted to get a permit to tear down and rebuild their beach house with a much larger home. And the California Coastal Commission said that they were concerned by the increased blockage of the view of the beach because of this bigger house, so from folks looking towards the beach on the front of the house side. But in that case, what they asked for was an easement on the beach side of the house for the public to be able to walk across the beach. And the court said, hey, wait a second here, guys. You asked for an easement on the back side of the house, but you said you were concerned about the ability of the public to view the beach from the front side. There's no nexus there, and therefore it's illegal. Next, we have this case out of Oregon, the Dolan v. City of Tigard case. And in that case, the Dolans owned a plumbing store, and they wanted to get a permit to double the size of their store and increase the parking area. And the City of Tigard said, well, okay, but we have this really nifty bike path that we'd like to put through here, and so we're going to require you to give us some land for the bike path, and we also we're concerned about some drainage here because there was a stream there in the back of their property, and they said, well, because of our drainage concerns, we're going to require you to also give us some land so we can do some runoff management. And the court analyzed this and said, well, yeah, there's probably some sort of relationship between them doubling the size of their store and needing to help alleviate congestion, and the bike path might be able to do that. Some people may very well walk to the store, or they may bike to the store to pick up small items. And they also said, yeah, it's a legitimate concern to be concerned about the runoff. But then the court said, well, but we don't have any evidence, though, that that what you've asked is reasonable when that it's roughly proportionate, to the impact that your project is going to cause. And the Supreme Court case here in Utah and the BAM cases came and they really helped clarify this standard. And so what the BAM case did is said that each exaction has to be roughly proportionate in nature to the impact of the proposed development. And what the BAM case said that means is that if you're going to look at a problem caused by a development, then the exaction has to be a solution to that problem. So for example, in the case of a store, there almost certainly would be an impact for transportation. And so if the government exacted some property to help widen a road, that would then be a situation where the exaction would help solve the problem created by the development, and that would pass constitutional muster. So that's what it means to be roughly proportionate in nature. You have to look at a problem caused by the development, and the exaction has to be the solution to that problem. The next analysis is where I think most of the time we see the problems. Most of the time, governments are able to come up with an essential nexus between a legitimate government interest and an exaction. That's usually not where we see problems. Oftentimes, governments also don't have any problem coming up with a solution to a problem caused by the project, and therefore we don't really see too many problems being roughly proportionate. Where more of the problems come in is this last prong, and that's where each exaction has to be roughly proportionate in extent to the impact of the proposed development. And what BAM clarified is that you have to take the monetary cost for the government to mitigate the impact of the development, and then you have to compare that to the monetary impact or value of what is being exacted. And those two items have to be roughly equivalent, is what the BAM court said. And so if there's a rough equivalence there, constitutional. If the amount the value of what is exacted is less than the cost of the government of mitigating the impact, great, constitutional. However, if what is exacted, its value is more than the cost of the government of mitigating the impact, not constitutional. And again, the courts have said this does not need to be an exact analysis, but there needs to be some kind of individualized look at this in order for this to be constitutional. So I know we've covered a lot here. If anyone's still there, I salute you for making it through all of this talking, this monologue. But if there are any questions, please let me know. I'd be happy to field them. Like I said, you may have specific questions that will come up, and do please feel free to contact our office anytime. We're happy to help, and hopefully at least this gives either a refresher of a framework that you already knew, a reminder of what things you should be looking at, or it gave you some new tools to analyze some regulations.
So we do have a question regarding right-of-way.
Okay.
And the question reads, I've had a couple of occasions where the private landowner had planted vegetation in the right-of-way, and when we went and exercised use of that right-of-way, the property owner squawked demanding payment for destroyed plants.
Sure. Yeah, we run into that sort of a situation on occasion as well, people calling our office, and the rule is if the private property owner went inside your right-of-way, they are trespassing. And so there is no right for them to be able to maintain vegetation to the extent that you haven't given it to them within your right-of-way, such that you would need to compensate them when you need to go in and alter things in your right-of-way in accordance with your, the ordinary course of maintaining the right-of-way for the public's benefit. So as a technical matter, that is not something that needs to get reimbursed. It's a trespass. And sometimes the question comes up, well, but I've had my trees there, or my fence or my whatever there for 20 years. I mean, don't I have some kind of either prescriptive right, or haven't I adversely possessed this property? And the short answer to that is no. That does not happen against the government is the short answer to that question as well. So yeah, thank you for that question.
So we don't see any other questions at this time. Jim's contact information is there on the screen, so feel free to contact him or us at any time, and we can help direct your questions in the right direction. We appreciate everybody tuning in today and participating in the webinar, and look forward to having you back again later. Thank you very much. Thank you, Jim.
Thanks, everyone. Thank you. Let me hit the record button there. No. Over here, options.
I'll go.
Either put everybody to sleep.